light's red, that's the camera thing again. We are live! Hi guys, how's it going? I know a lot of you are dual career agents still, or taking care of your kids, got families in business, but hopefully you're still watching this live, or this recording later on. We have the one and only Mansour, our legal updater right here, this amazing attorney right here. He's going to go over some very important documents with us. We do not want to get sued, right?
Yes.
We don't want lawsuits, right?
Definitely.
We want to know the legality behind our business, because you guys are a business. You guys know that, right? All right, take it away.
All right, thank you guys.
Whee! Okay.
Appreciate you guys having me out. So I would like to, first and foremost, I'd like to go over the updates that CAR did in June, okay? Because there's been some June updates to the forms a couple months ago. And they made a substantial updates to some stuff in December, but I guess they didn't want to give you guys everything at once, so they waited 6 more months and did some more updates in June. So now I will be going back to some December updates just to kind of give you some background about why some of this stuff is happening. So let's pull up the RLA, the new RLA. New improved RLA? RLA. There you go. Everybody see that?
Yes.
Yeah. Okay, so this is the hit all these, like, here we go. Residential listing agreement. As you can tell down here, this was revised
623.
623, right? You see that?
Right on the top here.
Yeah. So let me show you the provisions that were changed. So 4C has been added. Okay. So when you take a listing, you are going to be expected at this point to talk to your clients about their smart home features and what's staying, what's not staying. Section 4 has to do with what's staying what's going with the sale, what's not going with the sale. So you need to talk to your clients with now new and improved technologies, Alexas and whatever else is going on. People unlocking their doors through their phones and everything else. You should be talking to your clients about what smart home features are going or not going. Okay. CAR has seen an uptick in complaints about, people thought they were getting something with the house and didn't get it, things like that. Obviously, we're way past the flat screens now, right? There used to be a discussion about whether a flat screen should stay.
It stays,
right? So now we're way beyond that. Now we're talking about like things that, automation that, lifts up the blinds and things like that. So those are the kind of things you can have your discussion with your client about, the seller, about what's staying, what's not. Make sure everything is perfect. As you guys know, advertising that something stays or goes is not contractual, right? You can advertise it on MLS, not the same as having it in a contract, not the same as having it in your listing agreement. So if you want something communicated, you have to communicate that in the contract, counter offers, whatever, because the listing, the MLS advertisement is not good enough. I've dealt with a lot of situations where agents will say, well, it's on the MLS. Is it part of the contract? Yes or no? So make sure that anything that is, your client tells you is not going or going is in the contract. Now, I've even seen situations where the sellers don't, the buyers don't want something, but the seller leaves it behind because they're not told to take it. I had one where it was a hot tub or something, like an overground hot tub, and the buyers didn't want it, and it was not communicated to the seller to take it with them or dispose of it or whatever. It was still there, and the buyers had an issue with that. So just be very clear in your listing what's going, what's not going with the sellers.
Question.
Yes.
But wouldn't that hot tub, wouldn't that be considered as something that's actually attached to the property, where it comes with the property? I mean, it wouldn't seem like it's a personal appliance.
The basis of whether something's a fixture or not, because you're talking about a fixture.
Right. Yeah.
The basis of whether it's a fixture or not depends on a variety of things. So I don't know.
So at the end of the day, as long as it's agreed upon, it can be removed or removed, but you have to make it clear.
Right.
You know what, your chandelier is great, but we don't like it. It's going to be a pain in the ass to remove.
Chandelier is a fixture.
Right.
And if the buyer likes the chandelier, it should be on there. It says if the seller wants to take it with them, they should say we're taking the chandelier. Chandelier is a fixture. The other thing that's a fixture is drapes.
Yeah.
Drapes are fixtures. They're window coverings.
Yes.
According to the contract, they're fixtures. So if I had a situation where the seller wanted the drapes really bad and the buyer wanted the drapes really bad, and the seller was like, well, my mom made these drapes.
Yeah.
So, just be very careful.
I had a situation with the ring, the doorbell
Yeah.
ring. And the seller wanted to take it, the buyer wanted to stay behind. And so what the seller did would be like, fine, leave me behind, but I'm not releasing it. Because they have to delete their account from it, nobody to come in. So it was like a big old dispute. I just thought, let it go. I just buy a new one as a closing gift, basically put an end to it. But it came down to it like, okay, fine, I'll leave it, but I'm not releasing it.
How much does that cost?
It was like $2 something, so,
Yeah.
so it saved a bit of a headache, for
Yeah.
something, yeah. And my client was happy, so, yeah. But it was something of that nature where like, okay, I'll leave it, but I'm not gonna take my account off it, so good luck using it.
Right. No, I know. It's a big, it's a big thing nowadays with rings and all kinds of. So that's a new section, 4C. The other new section that they've added is section 10B. So 10B talks about presentation of offers. They want to be clear. They want you to be clear with your clients about when offers should be presented. There's a lot of buyer agent complaints to the board about their offers not being presented on time. There's a delay in presentation of their offers, whatever it is. But this is kind of you think of this as a get out of jail free card, right? If you're called in front of the board to defend why you didn't present an offer, but your instruction from your client was don't present it until a week later, 2 weeks later, whenever, all at the same time. You can actually show this to the board and say, hey, that was my client instructing me not to present the offers. So you need to have a discussion with your clients about when presentation is going to be, in what format, things like that. So just be aware that that's there, okay? That's a new edition in June. So have that discussion with your clients. Don't get trapped with, verbal communication about, when to present, not present. If anything changes, that your client changes their mind, present every offer as they come in, whatever it is, then, confirm that in an email, preferably. Okay, let's go back. Oops. Okay. All right, so the other thing I wanted to kind of touch on again, I touched on this last time, I believe I talked to you guys about this, but let's do it again, is the RPA. So there's still, obviously, this was a big change that was made in December, but it's still going to be an issue as we go forward because there's lawsuits involving NAR on the East Coast regarding sellers paying buyer broker commissions. So what CAR did is they added section G3, 3G3. So essentially what this implies is that you already have a contract with your buyer to pay your commission. And then what you're doing there is you're asking your seller to pay your commission instead of the buyer, or compensate you above and beyond what the buyer's already agreed to do. The reason why they're doing this is because they see a time going forward where the sellers will not be paying buyer commissions anymore. Now, it may not happen this year, it might not happen next year, it may not happen in 2 or 3 years, but it's gonna happen. So you guys need to kind of ramp up your thought process to having your buyers pay your commission on these. Here, go ahead.
So my caveat, or the way that I change the verbiage on that, is that I don't tell my sellers that they're paying commission. I say what my fee is, and I'll, out of my fee, pay the selling agent. Would that suffice?
Yeah. So yes, if your sellers, if they're agreeing to pay 6% and you're agreeing to share that commission with the buyer side, then there isn't really a change. But in the RLA, you're supposed to put how much you're paying the other side.
Right. Correct.
So when sellers get more savvy about that, and they say, okay, I'll pay you 3%, but I'm not paying them anything,
Okay.
then that's where, on the buyer side, you have to change your tactic. If you're on the buyer side. If you're on the seller side, it doesn't matter much to you on the listing side. But on the buyer side, I mean, how many times have you guys seen listings with like offering $1. Or listings offering
2 weeks ago, so.
offering $100.
I've seen it, yeah.
Or no money at all.
That's what the market is.
So they're preparing for that. They're preparing for that by having the discussions with your client about, your buyer client about paying your commission. Again, it's a value proposition, right? That you're giving your buyer the value that you provide for them to, close the deal. It's the same thing as giving the seller the value to choose you over somebody else, right? I mean, I don't think a buyer's agent does any less work than a seller listing agent, do they? I mean, maybe if not, the buyer's agent probably does more work. Sometimes they have to handhold the transaction, right? So you have to think about, securing your commission through the buyer side, okay? That reduces, if you have a contract with the buyer, and I'll show you what the contract looks like, which is the new contract that was put in place in November. Here we go. Oops, wrong one. Okay, so this is the BRBC. It's loading. Okay, this will like it. All right, this is the BRBC. It's the Buyer Representation and Broker Compensation Agreement. This is the front page of it. It's about a 3-page document. And this is the contract that's replacing all the other buyer representation agreements that existed. They used to have a buyer representation agreement for an open one. They used to have an exclusive one, all that stuff. This takes care of everything. This allows you to put in with your contract with your buyer about the price range that they want, the counties that they're looking in, whatever it is. Essentially, this allows you to secure your compensation, your commission, if they go around you and buy from somebody else. Let's say they go around you, go to a listing agent directly, or they go to the seller directly, and they close that deal. This document, legally, in court, can stand up for your right to get paid. Okay? Now, it's a different issue than procuring cause, right? Have you guys know what procuring cause is? Procuring cause is not a legal issue as it is a board issue. So let's assume you have no agreement, but you showed the house, but the buyer went around you anyway and went to the seller directly or the listing agent and then closed that deal. You can bring the other broker in front of the board and ask for procuring, for compensation based on procuring costs. That's not the same as suing the buyer. You can't bring the buyer in front of the board. The buyer's not a board member, right? So, but this allows you to establish a legal case against your buyer, because this is a contract between you and your buyer. Just like your listing agreement may allow you to make a case against your seller. Okay, so this is an important document going forward. It's not standard of the industry right now in Southern California for buyers to sign these documents, but CAR foresees a time where it will be standard of the industry. That's why they're jumping ahead of this. Okay. Now, I've seen very effective use of these agreements even before this whole mess came up with CAR. So, buyers agents have been using these for a long time. Let's say you agree with your buyer to pay you 2%. The seller's already agreed to pay 2%. Great. You can tell your buyer, hey, I'm going to get 2% from the seller. Nothing to worry about. Let's say the seller is offering you 1.5%, but the buyer's agreed to pay you 2%. Then great. You tell your buyer, hey, you don't have to pay me 2%, you got to pay me 0.5%. That's the way it's supposed to go, right? But you have to have an agreement in place first. Because the next thing after you have an agreement is you're going to turn around, if you want to, and ask the seller to pay your commission. 3G3. Okay? When you ask the seller to pay your commission, that assumes you already have an agreement with your buyer. And then you have to show the agreement to the seller. Okay? So, like I said, if the seller is offering 2% and your buyer already agreed to pay you 2%, you don't have to check off this box at all if you don't want to. Because there's no reason for you to ask the seller to pay you what you're already going to get paid anyway on the MLS, right? No worries. Now, I have seen a rash. I don't know if a rash is a good word, but I've seen some situations where the listing agents will reduce commission So they offered something on the MLS for like 2%, and then it reduced to 1.5. You guys seen that?
On the annual offers or on the MLS later?
On the MLS later, they adjust the MLS. You guys seen
Section on
that?
that form allows you to put as per the BAC that was on the MLS, like I think it's not section
Right.
3 or line item number
Yeah.
3 that protects that.
Okay, so don't fall asleep on that, right? Sometimes they'll adjust the MLS, and then and the other thing will be gone.
Yeah.
You know, some agents will take a snapshot of the MLS as it existed.
They're submitted with their offer.
Yeah.
The MLS is submitted with their offer.
Yeah.
You guys should look at the history too when it happened.
Yeah,
The
look at the
judgments,
history,
the
yeah.
changes that they made.
So just be careful with that. You know, don't. I've seen agents kind of get caught off guard when at the end of the transaction they think they're getting paid 2, but the MLS changed to 1.5. So be careful with that. Protect yourself early on in the transaction. Right? Now here's the trick. You cannot let your argument with the listing site about commission stop the transaction. Like you can't threaten to stop the transaction just because you're being offered less, because you have fiduciary duty to your client to close the transaction. It's something that you should close and then pursue after. Okay? You shouldn't threaten to torpedo the transaction because of your commission. That's a breach of fiduciary duty. All right? Okay. Oh, one more thing on the RPA, sorry. Okay, this is something I went over last time I was here, but let's go over it again. You see section L2? Okay, so this is not, you know, it depends on who you talk to, but right now this is not the market where this is going to be used too much, but it will be. So a car is always kind of behind the curve in terms of, you can say a car is behind the curve or ahead of the curve, because you know our business is cyclical, right? It goes up and down. So right now, who knows what it is, right? But there will be times again where the market will be hot again. So it used to be that when buyers wanted to signal to the seller that they wanted to be aggressive with their offer, right? What they would do is they would check off this box, and it says appraisal contingency based upon appraised value at a minimum purchase price or a different number. What buyers were doing is they were checking off this box and putting a number in there that's less. So for example, purchase price is offered at $500,000, however, it's being offered at $500,000, however, the buyer would say, I want to buy it, I want the appraisal contingency to be $450,000. What does that mean? That means that if it appraises at $450,000, I'm willing to come out of pocket $50,000. So buyers were being aggressive in that way. That's why they were checking the box and putting a lesser number in there. But then what was happening was sellers were getting all these offers. So a seller would do a counter offer that said, I don't want $500,000 anymore, I want $550,000. Well, if you're a buyer's agent and didn't catch what's going on, if your buyer accepts the counter for $550,000, then what happens automatically?
They gotta pay the difference.
You gotta pay the difference, which is how much is the difference? $100,000.
Yeah.
So what CAR did is they changed all the counter offers to a default. Okay? The default that all the counter offers, buyer counter offer, seller counter offer, and multiple counter offers have been changed to a default. The default says the appraisal gap is protected. So the buyer is not going to be caught off guard having to pay $100,000 because all of a sudden the appraisal contingency has moved from $450,000 to $500,000 to bridge that gap. Okay? So, because a lot of agents were calling CAR and saying, you know, we screwed up, I think. My buyer has to come out of pocket $100,000. They got a letter from an attorney saying they got to come out of pocket. What happened? CAR's response is probably like, well, you should have negotiated that before your buyer signed the damn counter. I didn't do that. Problem. So they put this automatic in here that says the appraisal gap is protected. Okay. The thing that changed from December, this was in December, the thing that changed from December to June when this was redone was they gave you an example. So now there's a complete example in here of what this means because people were very confused about why this was happening. So now there's actually an example. They use different numbers than I use, but if you read that, it's an example of what I just told you. Okay? The appraisal gap is protected. The appraisal contingency is increased to allow for that gap to stay the same. Everybody on the same page? Okay. So a lot of agents were, not renegotiating their appraisal contingency. Okay. And now, I don't know if I told you this before. What do you guys think the number one reason is that car changes the forms over and over again? What's the number one? Who wants to?
Amount of lawsuits and phone calls they get, the same issue, over and over and over.
Okay, so you said two different things. You said lawsuits and you said phone calls.
Yeah, complaints.
The reason it is phone calls. It's not lawsuits. Lawsuits are very slow and they don't happen that often, guys. Phone calls. So if agents call, like across the state, right? This is not Lake Elsinore calling. Across the state, if Cars Legal Hotline is getting 1,000 calls a day or 500 calls a day on the same thing, what's going to happen the next time they change their forms?
Yeah.
We need to fix this.
Address their problem.
That's the reason why the RBA is, went from
16.
over 16. 8, when I started it was 8 to 16, right? It doubled because of phone calls, not for lawsuits so much. Lawsuits have something to do with it, yes, but most of it is phone calls by you guys. So you guys are to blame. Blame yourself. All right, so we talked about the counteroffer. By the way, this is, like I said, this is all counteroffers, same language. Okay. All right. Talked about the RPA. Good. Okay. The other thing that they changed in June was they contingency removals. So let me show you the seller contingency removal first. Okay. Now, how often do you guys think CAR puts anything in writing on a half a page? How often does that happen? Okay. This exemplifies the fact, by the way, they split up the buyer contingency removal and the seller contingency removal.
Yeah.
But this exemplifies the fact that sellers don't have a lot of contingencies, guys.
Yeah.
Okay? So when a seller changes their mind for, their mom is sick, or they don't want to move anymore, or, whatever, or job loss, there isn't that contingency written into the contract. Okay? There isn't. Now, the most common contingencies, if you check out these boxes, are replacement property or closing on replacement property, finding or closing. Is that the same thing?
Pretty much.
No, it's not.
Finding, yeah, you're right.
Finding is easy.
Yeah, finding.
You identified it.
Yeah.
Closing is not easy.
You have to close it.
So if you mean to say closing concurrently, then say it. Because finding is not the same as closing.
Yes.
I've seen a lot of agents say, well, yeah, finding. Well, what the hell does that mean? Finding. You can get the escrow, but if you can't close, does that help the seller? No. So if you wanted to say closing. Concurrent closing, say concurrent closing. Now, there's another box in there with a line, so if there's anything else that the seller is worried about, put it in there. I'm worried I'm going to lose my job in the next 30 days, I don't know. Okay, fine. Let's put that as a contingency. Okay? I'm worried that if my mom's health gets worse, then I'll have to stay. Okay, fine. Let's put it as a contingency. Now, be as specific as possible with your contingency, not something, vague, but use it. Yes.
But that contingency would be written in your seller's counteroffer,
Right.
right? So that way it's written, because obviously it's not an RPA anywhere.
Absolutely.
Okay.
I mean, this is up to the buyer to send you, right? But they don't know what to send you if you don't have it already in the account, right? All right, yes.
On that too, I'm seeing a lot for 1031 exchanges. So if the seller is going to do a 1031 and then it doesn't work out for whatever reason, that needs to be on your seller counter,
Yep.
the 1031.
The 1031 is a little bit different because you have to find it within 45 days and you have to close within 6 months.
Yes.
So unless a buyer, if it's a closing situation, I don't know what buyer wants to wait 6 months for closing.
Yeah.
Most of the time on a 1031, finding is enough.
Yeah. But add it on your counter that they're doing a 1031 and there's a separate car form. So that's getting missed a lot.
Okay, good point.
Yeah. So.
1031, there's a different, what's the car form initials?
BXA, I want to say it's weird.
BXA?
It's BXA, right? Yeah.
Okay. What's the X stand for?
I don't
There we
know.
go.
Exchange.
Exchange,
Yeah,
oh, exchange,
exchange,
good, okay.
yeah.
Exchange.
Yeah.
You have to solve the equation for X.
All right, now let's look at the buyer contingency removal. As you guys,
This is a problem I had.
So you guys are not surprised to see that the buyer contingency removal is a lot more, right? A lot more pages, buyer contingencies, right? Buyers have a lot more contingencies, guys. A lot more contingencies. So, one of the things about the buyer contingencies is that you need to, as a listing agent, you need to be aware that what the market is doing. That's the tough part for your job as a listing agent, is whether you impose strict deadlines on the buyers to perform or not, contingency remove, to remove contingencies, etc., is dictated by the market conditions. If the market is slow and you don't have a lot of offers, you have a discussion with your client and say, do you really want me to press these buttons or not?
Yeah, do you really want me to present for a notice to perform? We don't have any other activity.
So that's a discussion That's a discussion that you should have. That's a discussion you should have with your client, not make a decision yourself. On the other hand, if the market is doing really well and there's a lot of buyers, then guess what? You need to stick tight to the document. Now, one of the things about disclosures is that the buyer has an out when they are given new information that's material, whether they waive contingencies or not. So if you delay on the listing site to provide whatever it is, HOA documents, whatever, if it's material information, the buyer can cancel even a few days before escrow is supposed to close, because they have new information and the contract is written in such a way where you cannot force the buyer to perform if the seller hasn't performed and they provide information that's late. Okay, so even if the buyer's removed all contingencies, and then you tell the buyer, oh, we forgot to tell you there was a big water leak last week, and we painted over it. The big water leak on the roof, we painted over it. Sorry, we already removed contingencies, so we're going to hold your deposit if you cancel. That's not the way it works. Once the buyer has new information, they can cancel and get their money back, even if they waive contingencies. Everybody understand that, right?
We have 5 days.
5 days. 5 days.
Would that apply also to the avid?
Well, yes. I mean, if you provide an avid that's late, that has material information in there, absolutely. It's all new information.
Do your avids, guys.
At the beginning, not at the end.
Now we're finding.
That's a hard one for us.
Well, you should probably do it, a lot of agents do their avids during initial listing.
Yeah.
Or home inspection is like, if you're the buyer's agent, do it at home inspection if you're there.
Okay, cancellation of contract. So this has always been the bane of CAR forever. I mean, if you were to ask them what percentage of calls that they get have to do with deposit or cancellation, they would probably tell you 60% of all calls. Because cancellations of contracts and deposit issues have been going on forever. There's no easy solution for them. CAR has tried to solve the issues as much as they can, but they can't. There's no perfect solution. So during the last iteration of the contract many moons ago, what they tried to do is they tried to involve escrow in it. And they had a section under section 14 that said something like, you can ask escrow to release the money. They have 10 days to communicate to the other side. If they don't communicate, then escrow can release the money. Was any escrow company ever doing anything like close to that? Did any escrow company release any money without mutual instruction? Ever. So no escrow company was honoring that section of the RPA because the escrow is not a party to the RPA.
Yeah.
So all the escrow companies were saying, I don't care what it says in the RPA. So they finally took that out. In December, they took all of that out of the RPA. That no longer exists. Escrow is no longer involved. But what they did in June is they made a very detailed advisory to your clients. And the advisory says something like, your agents are not attorneys. Talk to an attorney. Your agent can't tell you what to do with deposit. They're not capable. They're not capable. They're not versed in all the things that can go into the deposit issue. Okay, and CAR is correct. Deposit issues are not black and white most of the time. Agents will call me and say, "Here's a scenario. My client's getting their money back, right?" And I say, "I don't know. Your client's getting their money back because." even if everything you're telling me is 100% correct, a seller or the buyer can withhold deposit and it becomes a legal issue, right? So there's nothing forcing the buyer or seller to sign anything unless there's a court order, okay, that happens that tells them to do it. Simple example is like, this is a very simple example, and you guys will understand this very well. I mean, the loan contingency, right? The buyer cancels after 20 days in a 30-day escrow. They cancel because they're relying on their loan contingency. Should the buyer get their money back? I don't know. Did the buyer try to get a loan? What if the buyer didn't try to get a loan?
Yeah.
And held up the seller's property up for 20 days? Should the buyer get their money back? I don't know. Probably not. Right? What if the buyer tried 5 different lenders and nobody would give them a loan? Should the buyer get their money back? Probably. So the circumstances depend, it matters, right? What's going on matters. Are you guys able to give them legal advice? No. Car's telling you can't. Your clients want to come to you and ask you about their deposit. This is a get out of jail free card for you guys to show your clients. I can't give you advice because my board tells me I can't. I'd like to help you, but I can't. Here's what this document says. I'm not an attorney. I can't do it. So Carr tried to help you guys out by giving this big advisory. Okay. Cancellation and deposit are 2 different things, completely. I get questions all the time about, well, will I be allowed to close the transaction with another buyer? The answer to that is mostly a title question, because I'll give you the general parameters of it. If the buyer cancels the transaction, what does that mean?
They canceled and that's it. Like,
They don't want
they don't want the property, seller still owns it.
There's no fight over title. There may be a fight over deposit, but the buyer no longer wants the property. So when you go to a title company and say, okay, I have this cancellation from the buyer, I'd like to open up another escrow with another buyer, the title company says, shouldn't be a problem because the buyer doesn't want title. So the title company says, it's a safe risk. If the buyer doesn't want title, we don't care how much money is left in deposit, that's not our issue. We can close on the next buyer. If the seller cancels, no matter what the circumstances are, title has to be more careful. Why?
The buyer may want property still.
One of the buyer remedies for seller cancellation, if the seller is in breach of contract, is forcing the sale.
Wow.
So title has to be more careful with that because they're concerned if they close on another buyer, buyer number 1 may come out of the woodwork and sue everybody. Okay? So be careful. So that's one of the reasons why title is very careful with your cancellations. If buyer cancels, usually no problem. If seller cancels, you're going to have a little bit more roadblocks, perhaps, with title. Any questions on that?
No, sir.
Okay.
I have a question.
Yes.
So let's say,
I don't know if anybody can hear you over here, but
at the very
why don't you walk forward?
At the very last step, seller decides not to sell, and everything's already pretty much done.
Okay.
And how long does it take if the buyer was to, I guess, sue for court order or signature? How long does that take?
It depends on the county you're in. Really?
Riverside County.
Riverside County, probably a year.
A year?
Yeah. Some buyers, so these types of lawsuits we're talking about where the buyer tries to force the seller to sell happen when the market is really hot and the prices have gone up substantially. So I still have those types of cases that you're talking about. I have 2 or 3 of them left over from the last market, and the purchase price is well under market value. So the buyer is willing to put in the time because if they can get the property at market value back then, they're walking into a whole bunch of equity. When the market is going down, no buyer does that. They'll find something else. But it usually takes about a year.
The reason why I asked is because I was with an expired listing, and the agent they had was brand new and kind of did everything wrong. And pretty much they were going to be homeless, so they decided not to sell. But it was towards the very end. Like a notary came over to get that last signature and stuff, and they're like, no. And then the buyer and the listing agent were with her while everybody was signing, and she didn't want to, and the buyer agent said, well, we could sue you and force you to sell. And now I'm thinking, like, should I even, try to get the listing if it's going to take a year?
So here's the thing, and you bring up a good point, right? I have seen lawsuits, buyers suing sellers to force the deal, and I have seen sellers do a cross complaint against their own agent saying that they never told them what their options are for relocation. So it goes back to the seller contingencies. The seller contingencies are for replacement property. You should have the discussion with your seller about what they're doing next. It's part of your scope of duty, it's part of your fiduciary duty, is to ask your seller what they're doing. If they tell you they don't care about replacement property because they're moving out of state, whatever, you put that in writing. Okay, but if they tell you, I don't know what I'm doing, what do you, so it depends on the circumstances, but if that particular seller was never told about a replacement property contingency and she was left in the dark and they're going to be homeless, I can see an attorney suing the listing agent for it.
Question. So we're talking about, forcing the seller to sell. What about if the buyer, in the same case, seller cancels, hey, I'm not forcing the sell, but I'm going to come after you for damages. The buyer. Seller canceled, same scenario, says, you know what, that's fine, but I'm going to come after you for damages. I have moving force to sell and not damages, or?
So you can sue for damages, contractual damages. Usually the buyer damages, if they're not going after the property, is like you said, moving costs, appraisal fees, inspection fees, things like that. I'm gonna have a hard time making a link between the interest rate and the buyer damages unless the buyer forces the sale. Because I think if they force the sale, they can get the interest rate difference when based on what they have to buy for then. Okay, but the problem is that if they cancel, I don't think they're going to get any interest rate because they haven't suffered any interest rate damages yet because they haven't bought anything. Right. Now, if they buy something else,
they'll have damages.
It's possible.
Now they have a higher.
It's possible.
Okay.
Yeah. It's possible, but it depends on the circumstances. The buyer's damages are obviously more expensive than seller damages are. Seller damages, if you guys sign that if they sign that liquidated damages clause, it's the deposit. All they can get is the deposit. Okay. Now I had a client one time where he closed on a transaction. The seller stayed in the house. That happens from time to time. The seller doesn't move. The seller was supposed to be out, they didn't move. So what we did is we sent a 3-day notice to vacate, which is like an eviction of a seller. They didn't move. They moved like maybe a week or two later, but we already served them with a small claims case. So my client went to small claims court. They got the rental value of the property for those 10 days or 11 days, and they got moving expenses, and they got his hourly fee because he took time off of work, couldn't put himself back on the schedule for a day and a half. So it worked out. So that is possible. All right. The last thing I want to show you guys is this thing's not moving. Okay, this is the animal terms and conditions addendum. Oh, good. This replaces the pet advisory. You guys remember there's a pet advisory?
Yes.
So this animal terms and conditions addendum replaces the pet advisory. This is supposed to be an all-inclusive document that talks about the tenant's, this is a lease situation, the tenant's animal. They even ask you for the animal's name, I think, in here. What kind of animal you have, how many animals you have, the animal's name, what type of pet, what type of dog it is, everything. So this is something that Carl also wants to get ahead of because there's a lot of pet damage and management companies, agents involved in management get accused of allowing other animals to be in the property that destroy the property. Animals go in there that don't belong in there, things like that. So this pet advisory, animal terms and conditions addendum replaces the pet advisory. It's more extensive. So be aware that if you're doing anything with property management at all, be aware of this form. All right, I'll open it up to questions at this point. Anybody want to ask me anything on topic or off topic?
On the topic of getting rid of buyer's agents commission, realistically, like what I think is going to happen a lot sooner than a lot of people anticipate, and I know it's going to start. Well, I know Redfin already said that they don't agree with NAR that every buyer's agent's commission, every transaction should have a buyer's agent's commission, and I think it's going to start with all the major big platforms that have all the eyeballs on, that have all the eyeballs on the internet, on the houses, and it's going to basically start with them. And I know because I read the article, and I'm like thinking, Redfin's going to be the first one to start saying, just like they said, hey, we can list your house, sellers for 1%, it's going to be, hey, we have all the, we have buyers come directly to us and we can sell your house flat fee for this amount. And I think that's going to cause the whole snowball effect of the everybody. I mean, I'm pretty sure all the big players, all the iBuyers and so forth, I think will follow suit.
It really depends on. It really depends on the issue. This is the issue that's really a hot issue, right? Dual ending transactions isn't always the best way to go.
Right.
The problem with dual ending transactions, so essentially what happening is the buyers are coming directly to the listing agent. That causes more problems than it solves. Because dual agency, a lot of times, one side is going to say, you protected them more than me. It's going to happen. So if the market turns into all the listing agents capturing all the buyers themselves, I expect a lot more lawsuits. A lot more lawsuits. Yes. A lot. Because it cannot be handled well, especially if it's an individual agent. It can get better if the agent is giving their office a referral for another agent in the office to handle the dual agency. It's better. But one agent cannot do it consistently. The number one reason the agents get sued is probably dual agency. I'll give you a simple example. I mean, the contingency removals, right? As a buyer's agent, when do you want to remove contingencies?
Never.
Transaction closes.
In general, if the market is good, if it's not listing agent, when do you want to remove contingencies?
Yeah,
ASAP.
yeah.
So how can you give two instructions?
Yeah. So my thing with that is, for a while they were trying to end double ending transactions.
I think in California will.
Yeah, and now they're like, okay, now we're basically kind of forcing double ending because if there's no buyer commission, then why should you go for a buyer?
So this is the next step, and I'm telling you right now, and you guys can call me a liar if it doesn't happen. Okay. The next step of whatever this is going on is the CAR and NAR are going to go to the state legislature and end dual agency.
Okay.
You're going to end it.
I think that's most likely.
So what happens then? What happens then? So the buyer is not represented? That's a terrible situation.
But I know somebody that's in the East Coast with 6 of the states that are already implementing no buyer, and he says that basically you have one side, and it's basically there is no fiduciary duty. You're basically just a facilitator, but you don't have a fiduciary duty to the buyer or the seller.
That's never going to fly in California, though. So you would have to upend years of statutory law to say you have no fiduciary duty. Because, understand something, agency doesn't just occur because you sign a document. There could be implied agency in California. So your action, so you never sign a document with your buyer, right? You sign, you have your name on the RPA, which is not a contract that you sign with your buyer. You deal with the transaction, but you never sign a contract with your buyer unless you sign a BRBC. But you're still the buyer's agent, right? You give them an advisory saying, I'm your agent, right? Whether you give the advisory or not doesn't matter. Even if you don't give the advisory saying I'm your agent, it doesn't matter. If you act in the capacity of being an agent in California, you're their agent. So that the other states may not have the same framework of laws going on. The other thing is this: buyer's agents are going to have to get more. Not buyer's agents. Buyers are going to have to get more savvy. Okay. they're gonna have to say to themselves, am I being treated correctly? Especially if dual agency's over. If dual agency's over, then the buyer can't say, well, you were my fiduciary. You can't say that. You can't go to a listing agent and say, you're my fiduciary, because there's no more dual agency. So then the buyer is on their own. Then what happens is the buyer is gonna have to hire somebody.
And then with that dual agency ending, is it gonna be within the broker or the agent?
I think it's gonna be both.
Okay. All right, so you wouldn't even be able to be like, hey, Rudy, represent this buyer.
I think essentially what you're gonna have to do is you're gonna have to refer it out to an outside, eventually,
Another
to an outside brokerage and get a referral fee.
Yeah,
You know?
okay.
But I mean, that's gonna happen, yeah.
You know, countries like Australia, there are no buyer agents, period. Everything's done through the listing agent.
Is there an agency relationship between the buyer and the agent?
That I don't know, but I think somebody like Carr should send people there, because it's been going on there for years, and it works fine.
Okay.
And somebody should go there and say, well, how do you guys do this? You know?
Understand something, you know, these
Europe
other
is the same way. Europe is the same way. I just had somebody that came to Europe that has a property in Europe.
Yeah.
Same thing. It's a flat fee transaction. And he said, well, it come down in pounds, like $2,000. That's it. That's how they do real estate over there. Flat fee, $2,000.
But here's the thing, too. Also, here's the thing to understand. California law is much more strict on disclosures, on agency. So, yes, you could do a $2,000 flat fee transaction if you didn't have anything else involved, right? If you didn't have these disclosure duties.
Yeah.
If you didn't have your own duty as an agent to disclose stuff, right? You can do it, but the problem is you'd have to wipe out a lot of years of
Responsibility of another.
cases.
Well, the other thing too that I know will be tough in California is because a lot of people, housing, you know, for housing groups would say it would make it very difficult for a first-time home buyer to pay for a buyer's agent's commission if the seller's not offering.
Right.
You know, that'll take out, you know, that'll affect a lot of minorities, that'll affect a lot of first-time home buyers, is why they're getting a grant, you know, they had a hard time coming up with a down payment, now I have to come up with a percentage to pay for my buyer's agent. So that's another reason that, you know, I see that in California, it's gonna, you know, may take a while, or another reason that, you know, it might not affect us.
Not only that, but the lenders have to be involved in that too.
Mhm.
You know, the buyer has to come up with a commission. Okay, well, the lender has to be involved. You know, what,
Cost.
you know, the cost of the commission has to come up.
Another expense, yeah.
Yeah, and with FHA and VA loans, that may not be possible. You can't just tack on extra fees. Conventional loan, you can go to the listing agent and say, look, put 30 grand in there for the buyer's agent. They just jack up the price, and everything goes through. But you can't do that with some loans. You know?
Yeah,
It's going to be interesting the next couple of years, that's for sure.
it is. 'Cause where do the buyers get the money from? I gotta take out the MI, so they can afford to have that expense, you know, to the payments. I mean, it's a lot of questions up in the air. So.
For sure. All right, guys, well, thank you for having me today. I appreciate
Thank you,
it.
appreciate you coming over, appreciate it.
I was actually looking forward to this class. I never paid as much attention.
Rudy should be in the back.
Vaccine.
Sleeping, Facebooking. Ordering stuff on Amazon.
Catch up on your sleep.
Yeah.
Well, I've been doing it for a while, you know,